Order in the court. Be seated.
It's time for Talk Law Radio with Todd Marquardt. Todd Marquardt, attorney at law in Texas. If you're a millionaire or a thousandaire, Talk Law Radio is now on the air. Call in with your business law question, your elder law question, veteran aid, Medicaid, build a business to get paid. 210-308-8867. Or ask a question online at marquardtlawfirm.com. That's MARQUARDT lawfirm.com. And now it's Talk Law Radio with Todd Marquardt.
Welcome to Talk Law Radio. I'm Todd Marquardt. On the radio, on podcasts, on Facebook, and on YouTube. Now it's time for me to help you discover your legal issue blind spots by listening to me talk about the law on the radio. Today we're going to be talking about joint wills, contractual wills, reciprocal wills. Subscribe to our YouTube channel. Just go to YouTube and find the magnifying glass to search for Talk Law Radio. Then look for our Lady Justice logo in the red, white, and blue colors. Then click subscribe. If you want to be notified when new videos become available, click the image of the bell. If you enjoy this show, tune in to Talk Law Radio, AM 630 The Word, as well as 9:30 a.m. The Answer on Saturdays at 11 o'clock in the morning. All marriages are not the same. Therefore, the way married couples write their wills are not all the same. There are different ways for married couples to write their wills. It will all depend on who each spouse wants to name as beneficiaries. Some spouses have no children, and some have children from previous relationships. Some spouses want their collateral relatives to be beneficiaries, such as brothers, sisters, nieces, nephews, and maybe parents. Because of these variations, sometimes spouses do not fully trust one another. I'll say that again. Sometimes spouses do not fully trust one another. Now, when I was young and newly married, I would have never believed that. But now that I've been married for almost 25 years, and I've seen friends and family go through marriages and divorces, I do believe it. And sometimes spouses will treat each other with more disdain and hatred than any other relationship that they will have. So state legislatures and estate planning attorneys have developed different ways married couples can have their wills written. And first I'll talk about joint wills, reciprocal wills, and contractual wills. Making sure that these alternative will types are legally enforceable is detailed and difficult. There are court cases highlighting mistakes and misunderstandings about what joint, reciprocal, and contractual wills can and cannot do. There are problems with whether a will can be made irrevocable, whether a contractual will can require a surviving spouse to convey her property after the death of her husband to an irrevocable trust, whether an intended contractual will actually fulfills the requirements of state law, whether an oral promise to name somebody as beneficiary is enforceable as a contract, whether divorce after a contractual will is signed will cancel the contractual will, and whether a contractual will also restricts the surviving spouse's use of assets after death. These are all unique situations. They illustrate how each couple's family structure, intended future use of assets, and agreement or disagreement over beneficiaries affects the structure of the last will. There are other methods spouses can plan for their spouses and other beneficiaries, such as using living revocable trusts, irrevocable trusts, marital trusts, Q-tip trusts, bypass trusts, lifetime Q-tip trusts, spousal lifetime access trusts, and portability of the deceased spouse unused exclusion amount. The most important part of these decisions is choosing an estate planning attorney who is focused, friendly, and helps you confront these issues with compassion and grace. First, we're going to come up with some definitions. Married couples will often have an estate plan which provides for the distribution of their joint assets in the same manner. This plan is seen in reciprocal wills, two separate wills providing for similar distribution to the spouse or alternatively to the children. This is sometimes known as a I love you will or a sweetheart will. Next, I'll define joint wills. This is where two or more people executing a single will as the will of both. So it's a single document. The ones that I've seen that are joint wills were dated like in 1950. And my theory is that people would sign a joint will because wills were written with a typewriter. And it took a lot of time just to type these things out. So if a married couple used the same document, it would save, half the time of just typing. And so maybe that would reduce the cost. Okay, then there's the contractual will. Reciprocal will and a joint will is not necessarily a contractual will. Contractual will has to meet certain requirements, and we'll get into that a little more later. Joint wills are rarely used today. That's the one that's on a single document, right? Their use is generally limited to a case where the two spouses distrust each other. Now, I don't know why they remain married if they distrust each other, but you probably know somebody that's married and unhappy, and so maybe it's more common than we think. So if you're a person who doesn't trust your spouse and you want to make sure that the assets end up the way that you want, maybe you should do a joint will or a contractual will. A joint will permits each party to leave his or her property to the other upon condition that the survivor's program of disposition is agreed upon in advance. But there's no assurance that the instrument will have a binding effect on the surviving spouse, unless it's contractual also, as we will see. A further disadvantage is that the marital deduction probably cannot be obtained as to separately owned property if the will creates control over the survivor's program of disposition. The Texas Estate Code, Section 254.004, is contracts concerning wills or devises, joint or reciprocal wills. Section A says a contract executed or entered into on or after September 1st, 1979 to make a will or devise or not to revoke a will or devise may be established only by a written agreement that is binding and enforceable or a will stating that a contract exists and then also includes the material provisions of the contract. The execution of a joint will or a reciprocal will does not itself constitute sufficient evidence of the existence of a contract. Okay, now we're going to talk about some of these court cases that have evaluated some of these problems. And the first one is actually a court case from South Dakota, and I'm not going to be quoting the law as it applies, because it's not going to apply in Texas. It's the situation that I want you to be aware of. Denise and Neil had reciprocal wills in 2017. along with an agreement that neither would revoke or amend their wills without the other's written consent. After 2017, Denise and Neil started to fall apart, and Neil executed a new will, which disinherited her and named his children as the primary beneficiaries. Then he died. So there was a will in 2017 with Denise, and then there was a will in 2019 that he did by himself. And so after he died, Denise went to the court and said that the 2019 will shouldn't apply. The court concluded that the couple's agreement did not render Neil's 2017 will irrevocable, though it may subject his estate to liability. So what I've heard, or what I've read from reading some of these cases, is that the agreement, the contractual part of it, is a contract after death, just as it is during life. And if you break a contract, or you break your promise under a contract, well, there's damages there. But in this case, it doesn't change the fact that he did a new will. She would just have to file a lawsuit against the estate, which is really Neil. The estate now takes the place of Neil since he's gone. So that you just need to be aware that it's difficult, and there's a lot of details that have to be done to make sure that whatever it is that you want to happen actually happens. And in this case, Denise was frustrated. There's another case. This is a Texas case, estate of Hearn versus Hearn, out of Houston in 2003. Husband and wife executed reciprocal wills. Remember from our definitions, that just means that they were pretty much mirror images. He named her and she named him, leaving personal and household effects to the survivor, with the rest passing to a trust. The husband died first, and his children complained to the court that the will was contractual, and the contract would require the surviving wife to fund a trust with her property upon the husband's death. Well, this, the court said, was not written into the agreement. Contract did not require wife to maintain her will or transfer her property to the trust upon husband's death. Instead, the contract was fully formed when husband died and his residuary estate passed to the trust. So you have to be very intentional about what you want the will to do and what you don't want it to do. You have to be very clear. And I found some of these cases, they were summaries written by Professor Jerry Beyer, who was an estate planning and property professor at St. Mary's when I was there in 2006. And then he left St. Mary's to go work at Texas Tech University School of Law. Okay, here's another case where there was a contractual will. Each will named the other spouse as the primary beneficiary. If the spouse died before, the nephew was beneficiary. So after the wife died, the husband wrote a new will naming his niece as primary beneficiary. And then after he died, the nephew claimed that husband had broken the contract. Well, in this case, the court reviewed the law in Texas and held that these reciprocal wills did not meet the requirements of the statute. The court explained that although the will did state that a contract existed, it failed to state the material provisions of that contract. So you have to have both. You have to have a written agreement, and then you also have to have the terms of that agreement in the will. And I don't know if you believe this or not, but some attorneys will make a mistake there. And so again, part of the battle in getting your enforceable wishes completed is finding an attorney that's going to make sure that everything's taken care of, that both parts of this law are dealt with. Okay, let's talk about another case, the state of Gilbert in 2017. In this case, the two weren't married, and the woman claimed that the man promised her that she would be the beneficiary of his will. Well, he died, and she wasn't the beneficiary, and so she claimed that he broke the contractual wills statute. And the court said that his oral promise to name her as his sole beneficiary was not enforceable because Section 254.004 of the Texas Estates Code requires that to establish a contract to make a will, there must be a written binding agreement. Written. So now this woman knows what the definition of written really means. It's not oral. Okay, here's a case that came out in Missouri. But again, I just want to show you the fact pattern. In case this applies to you, you want to make sure that you clear these things up. Husband and wife executed a joint contractual will. So in my mind, that would be one document for two people that also contains a contract that divided the estate between their daughters by previous marriages on the death of the second to die. Here's something interesting. After 30 years of marriage, the couple divorced, and the ex-husband died a year later. This is important because divorce might have an effect on the will. In Missouri, if you get divorced, it automatically revokes the ex-spouse from your will. The ex-spouse is treated as having predeceased the deceased. And so I wanted to let you know that that's also the law in Texas. It's Section 123.001 of the Texas Estates Code, will provisions made before dissolution of marriage. Subsection B says, if after the testator makes a will, the testator's marriage is dissolved by divorce, annulment, or a declaration that the marriage is void, all provisions in the will, including all fiduciary appointments, shall be read as if the former spouse and each relative of the former spouse who is not a relative of the testator had failed to survive the testator. So that's like saying everything to my spouse. If my spouse is already deceased, then to Johnny and Joey. Well, even if there's a divorce, then the spouse is just deemed to have not survived for purposes of the disposition of the will. And by the way, testator is just the person that writes the will. Think about last will and testament. It's the person that wrote it. Just in case that strange word was a little confusing there. I had a case like this a while back where the woman was married to a second or third or fourth husband or whatever, and her biological son was written out. He was not even named in the will. It said that if her husband was already deceased, then it would go to his kids. Well, after she wrote that will, she died, and so all of those provisions about the stepfather and the step siblings were just invisible, and it was as if she had died without a will. And if she dies without a will, then it goes to whoever's related to her, and that was her biological son. So even though she didn't want him to receive anything, he received everything. So if you get divorced, it's good to write a new will. Okay, here's another case. Ernest versus Chumley. This is out of Illinois in 2010. Husband and wife executed mutual wills giving the entire estate to the survivor of them, and on his death to one half to his children and one half to hers. The wills were declared to be irrevocable on the death of the first to die. But after husband's death, wife remarried and signed a new will giving her estate to her new husband and then to his kids. The court held that because the will placed no restrictions on the surviving spouse's use of the property received from the deceased spouse, her children had no interest. So this is something that you can do, but we would use a marital trust or a Q-tip trust. In 2022, there were 61.44 million married couples in the United States. I found that on Statista.com. Here are some other methods that you could use besides a joint will or a reciprocal will or a contractual will. For clients that have estates that are separate in value, you might use a lifetime Q-tip trust to allow the wealthy spouse to transfer money and property for the benefit of the less wealthy spouse. And you can put stipulations in there. There's the spousal lifetime access trust, which is different from the lifetime Q-tip trust. An added benefit here is that it can be drafted to take into account potential divorce and remarriage. This is what those other people were trying to do anyway. One note about portability, that where you can use the estate tax exemption from the deceased spouse, even if you have no credit shelter trust in place. Usually you only have 9 months to claim that. You have to file a 706 estate tax return. Marriage imposes certain rights and obligations on spouses. If a married couple owns property and later divorces, then the divorce proceeding can handle that. But if you're not married, if you're just cohabiting and you break up but you own property together, it's really hard to divide things because you have to do it under partnership rules and not under divorce rules. Well, like I said, all marriages are not the same, so it's good to use an estate planning attorney. And attorneys at Marquardt Law Firm focus on business and estate law, including last wills, living trusts, and tax-protected inheritance plans. And you can find more information about this and other things at marquardtlawfirm.com. You can go to Marquardt Law Firm's YouTube channel to watch videos about various estate planning topics. Or you can go to talklawradio.com or the YouTube channel for Talk Law Radio and watch videos that way. You can go to podcasts if you're running, exercising, walking the dog. It's easy to listen to podcasts and YouTube videos. So thank you for spending a little bit of time with me. That's all we have for today. If you want to listen to more episodes, subscribe, or just turn on your radio at 9:30 a.m. The Answer or 6:30 a.m. The Word, Saturdays at 11 o'clock in the morning, and 9:30 a.m. Sunday afternoons at 4:30. I'm Todd Marquardt. I'll talk to you later.